The Fifth Amendment and our right to be free from self-incrimination is the next topic in criminal procedure. This is another area of crim pro that involves the exclusionary rule. Here, what we are trying to exclude, if we're on the side of the defense, is incriminating statements. So this is where the law of Miranda is testable. Miranda is one of the few case names that you need to be ready to use on any bar examination in the country and on just about every law school final exam. The Miranda rule establishes the principle that law enforcement has to advise a criminal suspect of his or her right to remain silent and of his or her right to have an attorney present during questioning, and also that any statement made pursuant to a consent will be used against that criminal suspect at a future prosecution. That's the essence of the Miranda warnings. And remember that the Fifth Amendment really only applies to situations in which the defendant is both in custody and being interrogated. And we'll see that both the words in custody and interrogation are subject to a fair amount of dispute. But basically what it turns on is whether or not the defendant felt free to leave. If the defendant felt as if he or she was being detained, any statement made as a result of an interrogation, questioning by law enforcement, is subject to potential exclusion under the Fifth Amendment. Probably the most common set of facts that give rise to a Fifth Amendment analysis arise out of a situation where law enforcement, rather than directly asking a question to somebody who is in custody, does what we call the functional equivalent of an interrogation. So, suppose the police have just arrested the suspect's in the back of the police car, the police are driving the suspect to the police station, and the police officer makes some comment that implies the officer knows the defendant is guilty. Suppose the cop says something like, most murderers don't leave the weapon at the crime scene, or something like that, which provokes the defendant into saying, you didn't find any weapon and I didn't do it. Something that would be considered at least somewhat incriminating. Well, under those circumstances, if law enforcement made the statement as a calculated effort to get the defendant to speak, we'll exclude that statement as being violative of the defendant's Fifth Amendment rights. But we can certainly imagine facts which would make the law enforcement officer's speech completely non-calculated to elicit an incriminating response. Suppose the police officer sees the defendant and says something along the lines of, "What are you doing here?" And the defendant says something incriminating in reply. Well, the more innocent the police officer's question, the less likely it is that the statement made by the defendant will end up being excluded. There are other very commonly tested scenarios going around the Fifth Amendment and Miranda. In particular, the situation where a suspect invokes Miranda. The suspect may invoke Miranda at the moment that he or she is warned, or the suspect may consent to an interrogation, but then during that interrogation, the suspect may invoke Miranda. Under either one of those circumstances, at the moment the defendant or the suspect invokes Miranda, questioning must stop, and if it does not stop, then statements made as a result of future questions will be excluded as a result of an application of the Fifth Amendment. Now, suppose we've got a situation where the suspect consents and agrees to be questioned after receiving Miranda warnings and after lawfully waiving those warnings. What can the police ask that suspect about? Answer: anything they want. So, suppose law enforcement has arrested the suspect on the grounds of unlawful possession of drugs. And as they discuss the topics with the suspect, they decide to ask the suspect about a recent bank robbery. And suppose the suspect makes incriminating statements with regard to a crime that the suspect was not arrested for. Is that testimony going to be admitted? Answer: yes. Once we've got a suspect who has waived his or her rights under Miranda, law enforcement can ask that subject anything they want. Now, at any time, the suspect can invoke Miranda, and at that point, the suspect has to be let alone. They can't question him or her anymore. One other fact scenario that comes up over and over again is where the suspect blurts something out before the police have a chance to Mirandize that suspect. Under those circumstances, the blurt out statement will be admissible. And one other area that is very regularly subject to testing is where we have law enforcement putting a snitch or some other person in custody with the defendant. And here we have to examine the facts very carefully. It is lawful for law enforcement to do this, to put a snitch or some other undercover agent in custody with a criminal suspect. However, we have to look very carefully at what happens. To the extent that the undercover operative asks a bunch of questions, the more questions that are asked and the more specific the questions, the less likely it is that the incriminating replies by the suspect will be admissible. But if we've got somebody who is put in custody with a suspect who's basically just hanging out and who doesn't ask anything more than, hey, what are you in here for, or something along those lines, those are circumstances in which law enforcement will almost certainly succeed in getting the incriminating comments made by the defendant admitted into evidence. Remember also, very commonly tested, a situation where somebody is questioned outside Miranda. Those statements are excluded. But remember, the statements are only excluded from the prosecution's case in chief. Where we have a situation where the defendant chooses to take the stand and testify in his or her defense, under those circumstances, the prosecutor is allowed to question that defendant about a prior confession that had been excluded as a result of a Miranda violation. One other idea that is very intrinsically related to this is the idea of coerced confessions. Coerced confessions are, generally speaking, not admissible at all. However, if they are admitted against a defendant, they will be judged based on the harmless error standard. So, if we've got a case in which there's compelling evidence of the defendant's guilt, the mere fact that a coerced confession was admitted against that defendant will not give that defendant the right to a new trial. And then finally, the last little detail that I want to cover with regard to the Fifth Amendment is the issue of immunity. Where law enforcement gives a grant of immunity to a potential witness, that witness has to testify because that witness no longer is under any threat of being prosecuted as a result of statements that are made. And both in that area and in the other areas that I've just touched on relating to the Fifth Amendment and the exclusionary rule, you'll see there's a fair amount of very intricate law that one could be tempted to spend an awful lot of time fussing over. My advice to you is get a hang for this material through practice. Annotate your outline with additional details that are a little bit too refined for a short presentation like the one I am making here. But keep your mind focused on where the points really are. The entire body of law of criminal procedure is less important than the law of negligence, and it is roughly equal in importance to the law of hearsay. So, criminal procedure has an awful lot of details, but taken as a whole, each of those details is comparatively unimportant. If you have a sharp understanding of the big picture of criminal procedure, you are unlikely to make dramatic errors on that topic. In the next video, we will turn our attention to the Sixth Amendment as it relates to the exclusionary rule.